Welcome to Panel 2. We'll launch our own damn satellite, California as a national and global force. I'm William Boyd. I'm a new faculty member here, relatively new faculty member here. I've been on the faculty at UCLA Law and at the Institute of Environment and Sustainability for almost exactly a year. And I'm thrilled to be part of the UCLA community and, of course, the Emmett Institute and all the great things that are happening out here. This may not be the best panel of the day, but we certainly win the prize for the best title. We'll launch our own damn satellite, of course, was the bold proclamation made by Governor Brown at the meeting of the American Geophysical Union in December of 2016 in response to a threat by the incoming Trump administration to shut down NASA's role in climate research. Governor Brown then made good on his pledge at the Global Climate Action Summit in San Francisco last September, announcing that California would partner with California-based Planet Labs to launch a satellite, more than one it sounds like, talking to Ken, and he can fill us in on the status there, to track and monitor the formation of various pollutants. Needless to say, Governor Brown's initial statement in 2016 and his follow-through last year were received with rousing enthusiasm around the world as a sign of California's unflinching commitment to fighting climate change, another example of the state's longstanding role as a leader, both nationally and internationally, on climate, clean energy, and the environment. As James Fallows put it in 2016, this is what the resistance sounds like. This panel will look at California's leadership role on climate, energy, and environment in more detail and its impact outside of the state. We'll focus specifically on how California has influenced other states here in the United States, how it has influenced the federal government, and how it's acted as a leader at the international level. We have a great lineup for the panel. I'll give some brief introductions. The longer bios are in the program. David Hayes is the Executive Director of the State Energy and Environmental Impact Center at the NYU School of Law, which supports state attorneys general in their advocacy for clean energy, climate, and environmental laws and policies. David also teaches at the NYU School of Law, and previously he was a visiting lecturer at Stanford Law School and affiliated with Stanford's Woods Institute for the Environment and its Precourt Institute for Energy. Before that, he served as the Deputy Secretary and Chief Operating Officer at the Department of the Interior for Presidents Barack Obama and Bill Clinton. He's also a former partner and global chair of the Environment, Land, and Resources Department at Latham & Watkins. He had a major delay coming in last night to LAX because of the power failure, so he's working on very little sleep, but he's had good practice to do a lot of great things with very little sleep. Ann Carlson, who needs no introduction, is the Shirley Shapiro Professor of Environmental Law and the faculty co-director of the Emmett Institute on Climate Change and the Environment here at UCLA School of Law. She's a leading scholar of climate change and air pollution law and policy. She's currently serving as the Speaker of the California Assembly's representative to the Independent Emissions Market Advisory Committee, and she's the recipient of numerous teaching awards, the UCLA Distinguished Teaching Award, the Ebby Award for the Art of Teaching, and the Rutter Award for Excellence in Teaching, and is the 2017 University of California Sustainability Champion, which is no small thing. She's also the co-editor of a brand new book, really literally hot off the presses, Lessons from the Clean Air Act, Building Durability and Adaptability into U.S. Climate and Energy Policy. She's co-edited this with Dallas Bertraw. I was fortunate enough to write a chapter for this book. It is a page-turner. You need to buy this book. It's in paperback, too. So the hardback is $100, but the paperback is a lot cheaper. So buy this book.
Actually, there's a Kindle version, too.
Who knew the Clean Air Act could be so exciting? All right. Finally, last but not least, Ken Alex is director of a new initiative, relatively new, Project Climate, at the Center for Law, Energy, and Environment at UC Berkeley School of Law. And before joining Berkeley Law, Ken spent 8 years as a senior policy advisor to Governor Brown, was the director of the Governor's Office of Planning and Research, and the chair of the Strategic Growth Council, focusing on climate, environment, and land use issues. Before that, Ken was the Senior Assistant Attorney General heading the Environment Section of the California Attorney General's Office and the co-head of the office's Global Warming Unit. And from 2000 to 2006, he led the California Attorney General's Energy Task Force, investigating price and supply issues related to the California energy crisis. We're going to follow the same format as this morning's panel. This will be an interactive discussion. I'll ask each of the panelists a fairly broad first question, and they'll have 5 to 7 minutes or so to respond, and then we may do some follow-up among the panelists based on their answers. Time permitting, we'll do another round of shorter questions and then open it up to Q&A with the audience. I'd like to save a little bit of time at the end for some short closing thoughts from each of the panelists. So we'll start with David. David, in your role as Executive Director for the State Energy and Environmental Impact Center at NYU, you're working on the front lines with states around the country in the fight against many of the Trump climate and environmental rollbacks. California has obviously been a leader in this effort, but other states are stepping up as well. Can you just tell us a bit more about your experience in this effort, the work that you're doing, and the role that California is playing and has played more generally in influencing other states to embrace stronger climate, energy, and environmental policies?
Sure. 5 minutes?
7. 7. And because of last night, we'll give you 8.
Yeah. So keep that excuse in mind. I was supposed to land at 8:18 p.m. I landed at 1 a.m. Thanks to LAX's electricity problems last night. I don't know anything about satellites. Very much on the ground at NYU, working with state attorney generals around the country. And I think it's appropriate at this symposium, as we rightly celebrate the incredible leadership that California has been showing in terms of affirmative action on climate change, that we spend a minute and recognize that we are in a war right now with the federal administration when it comes to climate change and environmental protections. And we have got to get through the next couple of years so that we can then bring to the rest of the country the type of innovations that California has. And let me just say on that score, we are seeing enormous change in many other states based on the leadership that California has shown. So the stage is set for tremendous progress around the country at the state level, and we hope at the national level. But there is an epic fight going on right now. I just want to paint that picture briefly and then talk about how the state attorneys general, including in particular your state attorney general, Javier Becerra, are dealing with the epic fight that is underway. Early on, when the president took office, one of his first comprehensive executive orders dealt with and instructed his departments to remove unnecessary burdens on the domestic energy industry. And the focus explicitly has been on the fossil fuel industry in particular, coal, oil, and gas. And his lieutenants, Scott Pruitt at EPA, Ryan Zinke at Interior, Perry at DOE, have saluted and then began a comprehensive effort to deregulate, in particular, climate-related greenhouse gas emissions reductions, as well as comprehensive protections that have been in place in a variety of other environmental laws, meaning that, and starting an unraveling of the underpinnings of our nation's environmental protection that we've been able to enjoy and build up over the last 40 years. State attorneys general have stepped up, as have environmental groups, obviously. And so what's happening? Well, I'm going to make 3 quick observations. First, to emphasize what I'm saying right now, which is the enormity of the fight and the importance of the fight is breathtaking. It is comprehensive. It goes beyond climate into other core clean energy and environmental areas. Number 2, I'm going to suggest that the state attorneys general are holding firm and winning. But I've got a couple of caveats where we now have teed up very important legal actions that will tell whether we can get through these 4 years relatively unscathed. And thirdly, I want to talk a little bit about your Attorney General in California and the leadership that he is showing and how other states are working in tandem cooperatively on this effort. First, in terms of the enormity of the fight, clearly, greenhouse gas emissions reductions are in the crosshairs of this administration. There's denial of climate change. Also, greenhouse gas emissions reductions, of course, hit the fossil fuel industry because it is the fossil fuel industry and the combustion of hydrocarbons that is the largest source of greenhouse gas emissions. The major sources of greenhouse gas emissions, 1/2 of all greenhouse gas emissions in the U.S. are released by either the coal industry, the transportation industry, or the oil and gas industry. Those are the three areas where the Clinton administration began to regulate and reduce emissions. The Trump administration is trying to roll them back. But they're also trying to roll back basic protections under the Clean Water Act by redefining and narrowing the scope of federal jurisdiction. They're aiming at toxics and doing rollbacks of hazardous air pollutants. They're looking at undercutting our disclosure laws, our NEPA laws, for example, and they're taking a look at cross-cutting policy issues and trying to undermine some of the basic underpinnings of our environmental laws, in particular, the calculation of how to define the benefits associated with environmental protection and the cost to industry. Now, I say that the AGs are winning. And there are scorecards all over the place. I want to point you to two scorecards that are interesting. One is kept by a sister agency a sister center of mine at NYU, the Institute for Policy Integrity that Ricky Revesz runs, the former dean. And you can find, if you Google policy integrity and regulatory roundup, they keep a running tally of who's winning the deregulation battle. And it's stunning. 38 out of the 41 decisions we've had so far have been against the government. Now remember, all of you law student types and lawyers out there, the government has a tremendous leg up when it comes to litigation, and yet they are losing most of these lawsuits. Why? Because in the first 2 years of the administration, they largely took shortcuts to try to put off deadlines, compliance deadlines for final rules that the Obama administration had put in place. And got slammed for it. Then they tried to do, okay, we'll do a rulemaking, but it'll be kind of a fake rulemaking. We're just going to put another delay, but have it underpinned by a rulemaking. They got slammed for that because they really didn't justify it. So a winning streak. On the other hand, now finally, because of those losses, the administration has developed comprehensive replacement rules, gone through the process, and is teeing up new rules for the waters of the United States, the Clean Water Act jurisdiction, and in the climate area, of course, the Clean Car Rule that Ann will talk about, the Clean Power Plan, which is the coal rule, and also rules in the oil and gas area for methane. Good so far, but scary possibilities here of what's ahead. Lots of need for good lawyering in the meantime. The other scorecard is the New York Times. On Monday, they just updated this. You can find it, Google it. They go down the list of 84 environmental rules on their way out. I find it very depressing to look at this list, so don't feel you need to. Look at the policy integrity list better. It'll raise your spirits more. But thirdly, I want to talk a little bit about how the state AGs are working together. It is stunning to me. I'm a bit player. Our center we support the state attorneys general. We have lawyers and communications folks actually in Washington. And then we also, through our center and our funders, we provide funding for some special assistant AGs that are physically in offices of progressive attorneys general in about a dozen states. And we have attorney-client relationships with a number of the main offices. We are witness to and participate in the coordination efforts that are going on nationally around these assaults to our environmental laws. And it is impressive and stunning to see how well these AG offices are working together and how significant, how good the legal work is and how significant the work is. Just a word about Attorney General Becerra. As you would expect, given this state, he has taken the lead in a lot of the greenhouse gas emissions issues, including the Clean Car Rule, the glider truck loophole. In the methane area, he's been leading the fight to hold on to the new source performance standards for the oil and gas industry. He has filed suit to require EPA to move on existing sources of oil and gas methane. He filed suit to force EPA to regulate on a timely basis methane emissions from landfills. Under the Clean Power Plan, he and the Attorney General of New York have together led that effort, which the second chapter of which will soon drop. We're expecting within a matter of weeks the replacement rule for the Clean Power Plan governing coal to come out and to begin the battle that will follow. Energy efficiency with the Department of Energy's energy efficiency requirements, he's been leading that as well. He's also led, though, efforts in not only that core climate area, but he's co-led the effort to deal with the rollbacks of the Endangered Species Act. He participated in the Migratory Bird Treaty Act rollback litigation, and he's been deeply involved in some of the cross-cutting policy issues that may be the most pernicious parts of the Trump agenda. For example, just a couple of months ago, he brought a lawsuit with the Attorney Generals of Oregon and Minnesota against the EPA for their so-called 2-for-1 regulatory rollback plan. The Trump administration says that for every one new regulation, you have to roll back 2. This lawsuit raises really interesting constitutional separation of powers issues in the new lawsuit. Likewise, there's a rollback for hazardous air pollutant control called the once in, always in policy. General Becerra was at the head of that as well. And finally, if there's a chance on a second round of questions, I want to talk a little bit about how he has led many of the states in defending our public lands as well. There have been a lot of insults to the public lands coming out of this administration, and he's been at the forefront of that, which has been very important because the West has not had many AGs until very recently that are attentive to public lands. But we now have a new AG that's progressive in Colorado and Nevada, for example, as well as Washington, Oregon, New Mexico, and California. So I'll stop there and look forward to following up.
Great, thanks, David. And we'll definitely come back to the public lands point. So, Anne, you've written a lot about federalism in U.S. environmental law. You focus specifically on the iterative relationship between the states, and particularly California, and the federal government on climate and air pollution. Obviously, that relationship is under enormous strain at the moment, as David's comments make clear. But stepping back and looking at this historically, can you reflect a bit on the importance of this model of iterative federalism, a term that you coined in a Law Review article some years back, for U.S. climate and air pollution policy in general, and then say a bit about the specific challenges that we currently see with the California car standards?
Sure. And one thing I think you should take from David's comments, those of you who are law students or lawyers in the room, is that environmental and climate policy right now is a full employment act for lawyers. And it's great how many former students we have in the audience today, current students, many of you doing really important and impactful work around the state of California and beyond. And so it's one of the great legacies, I think, of the support that we've received for environmental and climate law and policy at UCLA. So it's great to see all these faces in the audience. So I do want to go back historically to talk about California's special role in air pollution regulation, in part because I think it has real lessons for us moving forward and highlights why the Trump administration's attack on California authority is so pernicious and so potentially problematic in the context of trying to solve the greatest existential environmental crisis we've ever faced, that is, of climate change. So let me start with a little bit of definition. So as you may or may not know, the Clean Air Act says that any state that was regulating air pollutants from tailpipes as of March 1st, 1966, can continue to do so as long as it receives the permission of the federal government through what's called a waiver. And the idea of a waiver is that the state gets waived from a preemption provision that otherwise prohibits states from regulating tailpipe emissions. The only state regulating as of March 1st, 1966 was the great state of California, although New York was on its heels and was actually going to issue standards that were tougher than the California standards. That led to Congress preempting other states because the auto manufacturers argued that they did not want to have to meet a series of tailpipe standards across the country. California managed to secure for itself this special authority. And that special authority has been used in incredibly important ways, and I want to focus on one of those. But let me first tell you why I think this is a process of what I, as William said, called iterative federalism. The idea of iterative federalism is really twofold. One part of it is that California often leads on mobile source standards, and then if successful, the federal government adopts what California has done. But importantly, and I think this is a really important part of the story, California doesn't lead in a vacuum. It leads in part because the federal government requires it to under the Clean Air Act. And so there's really a push and pull of federal law and federal authority over California to make sure that it's meeting air pollution standards, combined with the special authority that the state has that has led to this extraordinary leadership, and that leadership has then transcended air pollution to cover greenhouse gas emissions with the first bill introduced by Senator Fran Pavley, again sitting in the audience, AB 1493 in the early 2000s. So I want to talk about what might be the most important example of this iterative relationship, and again, why California is important, but so is the federal government, and that is an important part of the story about the California waiver for greenhouse gas emissions going forward. So California set the first standards for tailpipes in the mid-1960s, at a time when there was no federal preemption. It then was preempted. When it set those standards, it's important to know that it set them based on existing technology, what we call technology following regulations. So the auto manufacturers could comply with these standards pretty easily with off-the-shelf technology that they had in fact hidden and were sued under the antitrust laws for doing. But the technology existed. And so it was relatively easy to cut emissions by about half for their uncontrolled state in the first round of emissions. It's the next round that was really transformative. And that round occurred not just because California exerted leadership, but because Congress enacted the 1970 amendments to the Clean Air Act. And there were two provisions that were especially important to what many people describe as the greatest environmental technological development perhaps ever. And that's development that has actually been transformative across the world for air pollution. So there are two provisions that were important in the Clean Air Act, as I said. The first was that the Clean Air Act set up the National Ambient Air Quality Standards Program that set background limits for a series of common pollutants. And if you want to know more about the NAAQS, William's chapter in the book that we just issued is actually an extraordinary history and description of the NAAQS. And so that chapter alone is worth buying the book for. It's a page turner, absolutely. You won't be able to put it down, I guarantee it. So the NAAQS provision is one. The other piece that's really important is that Congress required the auto manufacturers to cut air pollution from tailpipes, 3 different pollutants, by 90% by 1975 and 76, depending upon the pollutant. Okay, that's from 1970 to 1975, cut 90%. That was extraordinary. It was an extraordinary demand. And if you think about the auto manufacturing cycle, it was a very short period of time to meet that because 1975 model years are actually issued in 1974. So in this very short period of time, manufacturers had to do something that they had not had to do before, and that is to develop technology. So this is technology forcing as opposed to technology following. And the technology to meet those standards did not exist at the time. In fact, those of you who are old enough in the room to remember, Lee Iacocca was way out in front in blasting Congress about the demands that Congress was making to get the auto manufacturers to cut emissions. He was in 1970, he was the executive vice president of Ford. He later became the chief executive officer and was ubiquitous in commercials, et cetera. He's probably the most famous auto executive ever. Here's what he had to say about the 90% cut requirement. The levels for 1975 models are lower than any we know how to meet. If such levels are established, the technology as we know it today would not permit us to continue to produce cars after January 1st, 1975. So it's not the first time that auto manufacturers threatened to shut down production, and it would not be the last. But it's important that that's the kind of message that Congress was getting, and yet enacted the standard in any event. So what happened after the passage of the 1970 amendments? Two separate tracks for the auto manufacturers. The first track was actually to try to meet the 1975 standards through a huge deployment of R&D, not only by the auto manufacturers, but by a couple of other important companies to develop the technology that could cut emissions that dramatically. Two companies were particularly important. One was called Engelhard and the other Corning, the glassware company. And they immediately poured resources into trying to figure out how to take what was then pretty rudimentary catalytic technology that actually did exist and figure out how do you mass produce it, how do you make it last for 50,000 miles per car, which is what the standard required, and how do you get it to market by fall of 1974 on 10 million cars. Pretty extraordinary process that the auto manufacturers faced. Corning was famous for developing a particular structure for the catalytic technology called the honeycomb structure that continues to be in existence today. And Engelhard was the first to produce really what could be a working mass-produced catalytic converter that ultimately actually reduced 3 pollutants. At the time, it was just 2. But even more importantly, perhaps for the public health story, Engelhard faced a big problem. All the manufacturers did. Catalytic technology eroded very dramatically with leaded gasoline. And what Engelhard figured out is that if you used unleaded gasoline, the catalytic converter would last. That led to EPA requiring gasoline stations as of 1973 to offer unleaded gasoline, which becomes probably the single biggest public health achievement, and I'll talk about that once I get through the rest of the story. So this huge technological drive is going on to try to meet the standards. At the same time, auto manufacturers do what auto manufacturers are good at. They sue the federal government, and they start pressuring Congress to relax the standards. And there's a real hero in this story, and that is the first EPA administrator at the time, William Ruckelshaus. You may know his name from environmental stories. You may also remember that he was famous for refusing to fire Archibald Cox. He left EPA and went to the Justice Department and was famous for standing up to the president and then was fired himself from the Department of Justice. Also came back into the EPA in the 1980s after Ann Gorsuch, mother of our current Supreme Court Justice, was unceremoniously forced to resign from the Reagan EPA to try to restore some of the goodwill EPA had previously had to the agency. So Ruckelshaus really stood up to the car manufacturers. There was a provision in the Clean Air Act that allowed him to delay the implementation of the standards if there was evidence that they were going to be impossible to meet. Despite a National Academy of Sciences study saying the technology was really not quite ready, he held his ground. And he said, no, I think it's here. 1975, you're going to have to stick to that date. The car manufacturers sued and won in the D.C. Circuit Court of Appeal with a court opinion saying, we're going to delay the standards. So the car manufacturers bought themselves an extra year, except Ruckelshaus had another weapon, and the other weapon was California. So this is where the NACs become extremely important. So California has the special authority to regulate mobile sources. It also is required to meet new standards for oxidants and all sorts of air pollutants. And it has the dirtiest air basin in the country within its boundaries, and that's Los Angeles, right, the whole of the Southern California area. Just to give you a sense for how extraordinary the new standard was for oxidants and how difficult it was for Los Angeles to meet, I'm going to read you something from the Federal Register that was published at the time about California's waiver request to be able to continue to regulate mobile sources. In 1970, the oxidant standard was exceeded at some location in Los Angeles on at least, anybody want to guess how many days? 250 days a year, okay? The maximum 1-hour reading in Riverside exceeded the national standard nearly 8-fold, 8 times higher than the national standard. During 1970, a full 10% of the oxidant readings in the basin were 5 times the national standard or higher. And remember, the national standard at the time was significantly higher than it is today. So we're talking about levels of air pollution that we haven't seen in years in California that were quite extraordinary. So against this backdrop, what does Los Angeles need to do and what does California need to do? It needs to go after the biggest culprit of air pollutants, and that is automobiles. But it can't do that unless it has the authority, or unless it gets a waiver from Ruckelshaus. Ruckelshaus is facing the same kind of pressure he's faced in court and from the auto manufacturers and from Congress, with the auto manufacturers saying, we can't meet the California standards. We don't have the existing technology. We can't get this huge number of cars ready for purchase for the 1975 model year if you force us to comply with California standards. Ruckelshaus grants the waiver. He decides that California is essentially going to be a guinea pig for the rest of the country. We're going to figure out, does catalytic technology actually work? Can we mass produce it? Does it force cars to fall apart, which is what the auto manufacturers predict? Does it wreak havoc on gas mileage and so forth? And lo and behold, the auto manufacturers actually, with the exception of Honda, which uses a different technology, install catalytic technology on virtually every car sold in California, and it works. And that begins the implementation of catalytic technology on every car in the United States, and begins an extraordinary decline in air pollution as a result. So not only that, but because new cars had catalytic technology installed on them, they needed to use unleaded gasoline. So unleaded gasoline becomes prevalent, and over time, as the old cars get driven into oblivion, we no longer need leaded gasoline. So that makes it much easier as a political matter. Remember Mary's line about how Governor Brown has figured out that you don't want to piss off a lot of voters? Well, you don't piss people off as much if they don't need the product anymore. And the catalytic converter really led to the obsolescence of leaded gasoline. Let me just, one little diversion about leaded gasoline. So at the time that we had lead in cars, lead is extraordinarily heavy, and it would deposit on surfaces everywhere. I once heard a public health official say that if lead was green, the surface of the earth was covered in it. And as kids, so I always say I've lost about 10 IQ points as a result of lead. As kids, you play on the monkey bars, covered in lead, you stick your hands in your mouth. The average lead levels of kids in the early 1980s in the United States was about 14 micrograms per deciliter of blood. The average now is under 1. And there are many scientists who think that that's led to things like decline in crime, all sorts of behavioral issues, increases in IQ, and so forth. Probably the single biggest public health achievement that environmental law has accomplished. Why? Because of the development of the catalytic converter in many respects. Why was the catalytic converter developed? Because we had this sort of dual relationship between California and the federal government, with the federal government bolstering California's authority, but also requiring California to issue a plan to figure out how it was going to come into compliance with those NACs that were so difficult to meet. Since 1975, the catalytic technology has improved dramatically, and in fact, one of the things that Mary Nichols oversaw as board chair in her first iteration in the mid-1970s was the expansion or the improvement of catalytic technology to remove not just 2 but 3 pollutants. She tells a story about driving, I think it was a motorcycle outfitted with a catalytic converter to demonstrate just how much cleaner the exhaust was from coming out of the motorcycle. And let me tell you what that's done for Los Angeles air. And I'll tell you about Los Angeles, but this has repeated itself in jurisdictions around the country and around the world. So I gave you some background about how bad the air was in the 1970s. Let me give you a little bit more. In 1973, Los Angeles had about 125 days of stage 1 smog alerts. So those are the most extreme. Those are the ones where if you were a kid growing up at the time in Southern California, you were told to stay indoors, you were told not to exercise heavily, your eyes burned regularly. This is a third of the days of the year. I always say I have the lungs to show for it. How many stage 1 smog alerts have we had since the year 2000? 0. Zero. We've had no stage 1 smog alerts in the past 20 years. That is the accomplishment of the catalytic converter and other technological developments that came because of combined California federal leadership on air pollution. Catalytic technology has not been limited, obviously, to California. It's standard now across the country. It's also standard around the world. So Chinese air pollution is bad. It'd be a lot worse if Chinese cars weren't outfitted with catalytic technology, which is now required in China. Same thing in the European Union, same thing in many, many countries around the world. That also leads to the banning of lead in gasoline, right? Or at least the phase out of lead, because cars now need unleaded gasoline. Again, extraordinary public health benefits. One more stat, and then I'll close with a few comments about the current waiver debate. So the overall health benefits that have been developed or have been delivered by the Clean Air Act between 1970 and 1990, put aside what's gone from 1990 forward, are about $23 billion. Trillion dollars. I got the B and the T mixed up there. $1 trillion at a cost of about $500 billion. So we spend a lot of money to accomplish health benefits, but the ratio of benefits to costs is 42 to 1. So the technological developments have paid off in extraordinary reductions in sick days, increased health, lower mortality, and so forth, largely as a result of this combined California federal leadership. So let me say a word about the battle going on today over the California waiver. So as you're all familiar with, the Trump administration is threatening to do really 3 things that are important. One is to freeze or to roll back greenhouse gas emission standards that are nationwide for passenger automobiles that came out of California standards from 2025 levels to 2020 levels. They haven't issued the rules yet. There's some monkeying around with that. They're also planning to revoke California's waiver to issue its own standards, not just for greenhouse gases, but also for zero-emission vehicles, which are extraordinarily important for the state to try to continue to cut air pollution from the South Coast Air Quality Management District, from the Central Valley, which is also routinely out of compliance with the number of the National Ambient Air Quality Standards. And so it's going after not just Greenhouse Gas Emission Authority, but also Conventional Air Pollution Authority. And I'll just leave with the thought that my biggest worry about the revocation of the waiver, should it go forward, and I was heartened to hear Mary think that she thinks it may not go forward, but if it does go forward, that what we really lose is we lose technological innovation. And that's innovation that helps not just California and not just the rest of the country, but it's transformative for the rest of the world, and that's really what we need right now. I'll stop there.
Great. Thank you, Ann. Ken, you served as Governor Brown's chief advisor on international climate initiatives and were really the force behind the Under 2 MOU, among other things. And it sounds like in your new role at UC Berkeley, you'll be continuing with some of this work. Can you tell us about some of these initiatives and offer some reflections on California's role as an international leader?
All right, so we're covering everything here.
We are, yes.
The whole gamut.
We've been expanding out. We're going to the solar system.
We're at least going to the satellites.
Yeah.
So first off, it's a little bit ironic that I ended up being the international person. I was the director of the Office of Planning and Research, which is focused on local governments in California, which you can now see the connection, so maybe it wasn't so well. So I went to a meeting with Governor Brown, who was meeting with the foreign minister, or the environment minister of a state in Germany called Baden-Württemberg, which produces a lot of Germany's cars, by the way. And the two of them were commiserating. This was about a year and a half before the international meetings in Paris, and they were commiserating that these two large economies, because they were subnational governments, really had no voice in the international process, and was there any way to change that? And so Governor Brown turned to me and said, well, Ken, what do you want to do about it? So I said, okay, I'll do something. And so I drafted something that I called the Under 2 MOU, which over time became the Under 2 Coalition. and now has about over 200 subnational governments around the world, representing about 40% of world GDP. These are subnational, like states and provinces primarily, some cities, but all of which are interested in doing more on climate and are perplexed by the slow progress internationally. So that's how I came to this, and I'll just talk for a few minutes about sort of the extent and breadth of what California does internationally. When Jerry Brown became governor in 2011, you may remember, it seems like a long time ago now, but we were in a significant recession, the Great Recession, in fact. And Jerry Brown's focus and the focus of everyone in the administration was California, first, second, and third. And so there was not a lot of interest at that time in looking at international issues, and I think there was some feeling that Schwarzenegger, who had a very internationalist view, that we needed to kind of pull back on that a bit. And so we spent quite a lot of time thinking about what to do about climate in California and its relationship to all kinds of other issues, particularly in my case around land use planning. You can think of just about any issue in climate as a land use issue. And so we spent quite a lot of effort on that. But what happens, and I suspect we'll see that in the current administration as well, is that, you know, California is an international entity. There's no State Department. As Mary noted, we no longer have trade offices. But a lot of the world still looks to California. And as Ann just said, standards promulgated in California become international. And so climate, of course, is global. And, you know, the silver lining is you can't make this happen in terms of the change we need without collaboration and cooperation. And then as California is very happy to repeat often, California is the world's 5th largest economy. And that has a lot of elements of trade. But it's also the case that as a result of the federal administration and its complete abject failure and worse, you know, its denialism, et cetera, that countries around the world and needed an alternative, not least of which I would say China. So there's a long history of China-California cooperation, particularly around criteria pollutants. China has sent many of its engineers and technical folks to work and actually stay with the Air Resources Board in California over a period of many years to learn how the regulations work, and particularly why in California, as a result of things like the catalytic converter and other efforts, the emissions in California have been reduced by 95%. Criteria pollutants have been reduced by 95%, black carbon, et cetera. It's pretty extraordinary, and the Chinese and others have noticed and have taken, you know, quite a lot of action based on California's work. So it's not a surprise that California is part of a lot of an international effort around climate. And once the recession receded, and there was, you know, Governor Brown, I think, is somebody who is particularly focused on climate change. You know, he's now 81 years old. You wouldn't know it, but he thinks more about the future than, you know, people in their 20s, and it's really extraordinary. And this is one of the key issues for him. And so, as he was contacted by many governments around the world, he gave a green light to do more, and he himself did a lot of traveling internationally to China, to a number of the conferences of the parties, and we built kind of an international set of efforts. So I mentioned the Under 2 Coalition, and I'll talk a little bit about how that might be used in the future. There are many bilateral agreements, a lot with China and Mexico, Germany, et cetera. Cap and trade, of course, is an international effort, and right now it's just California and Quebec. Ontario had joined as part of the cap and trade program, but the election in Ontario changed that, and they withdrew. That underscores how important it is to have broad-based coalitions because politics change, and Trump is a really unfortunate example of that. Meanwhile, China has taken, again, quite a lot of notes on California's cap and trade effort, and we've had, I still say we, I haven't kind of gotten past that in my 5 months off. But California and China have done a lot of exchange around cap and trade, and California is working with a lot of other countries, New Zealand and others around the world and in Europe, on cap and trade efforts and the potential to link markets, which could be quite important. California helped create something called the Pacific Coast Collaborative with British Columbia, Washington, Oregon, and California. And out of that has grown something called the Ocean Acidification Alliance. These are, kind of exciting titles. But as you can imagine, a rather important topic for California and for jurisdictions around the world that have coastlines. And that organization and its membership are building plans to deal with ocean acidification, which is possible to do, at least to a certain extent, by doing things like planting seagrass and having very localized efforts to reduce acidification in local waters. There's something called a electric vehicle collaborative. That's an international effort that's hugely important to building markets, and that actually works collaboratively with automakers as well. And there's something that William is very involved in called the Governor's Climate and Forest Task Force, which California, interestingly enough, was one of the founders in the Schwarzenegger administration.
Governor Schwarzenegger, yeah.
But that focuses on subnational action around rainforest protection and building economies in places like Acre, Brazil, around protection of the forest. So all of these things are driven to a large extent by California's participation and by its size and by the interests of jurisdictions around the world to work with California. Some of it, to be honest, is countries want to have an association with California, with Silicon Valley, with the potential for trade. That's great. I think California's been happy to go in that direction. Now, to me, the biggest hurdle in dealing with climate is not climate solutions. There are many, many solutions and technologies that can move us hugely down the road to resolving climate change and greenhouse gas emissions. The bigger problem is how do you bring those solutions to policy and to scale? And so that's exactly what my effort at Berkeley is going to be focused on. How do you move an idea that has the potential to reduce emissions quite drastically and get it taken up in the time frame that Kara mentioned at the outset, that we have to get a 40% reduction in California and worldwide in less than 11 years. That's an extraordinary set of changes for political systems that hate change. And so, one of the things that we're going to be doing is to work with China. Jerry Brown is going to be the co-head, along with Minister Xia in China, of California-China Climate Policy Institute. And so one thing that we can do is to think about taking California solutions and piloting them in China. You immediately get to scale. So that's one approach that we're thinking about taking. The Under 2 Coalition, this entity with 220 subnational governments that want to do more, is another, it's a delivery system in my view. It has jurisdictions everywhere in the world with different types of economies, from rainforest economies, developing economies, some of the most sophisticated economies. There are multiple possibilities for getting California solutions to different jurisdictions, hopefully quickly, where subnational jurisdictions are often more nimble than national jurisdictions. So that's the thinking, and that's hopefully part of the legacy of California. My sense is, without speaking for the Newsom administration at all, is that they're looking domestically first. Again, just very much like the Brown administration. It makes a lot of sense. We have lots of problems in California, housing inequality, et cetera. But over time, because of California's role in the world and role internationally, there will be a lot of interest in California, again, having a very direct interface with countries like Germany that want to do more but don't have a partner in the United States. And I think that's underscored by the victories of the Green Party in Europe in the European elections. And I think we're going to see a fair amount of outreach to California because they've got really nowhere else to go in the United States. California will work with other states, but they can't go to the Trump administration. So my hope and expectation is we'll see a very substantial continuation and building of a legacy that started probably in the Davis administration, when the Schwarzenegger administration, the Brown administration, and now the Newsom administration.
Great. Thank you, Ken. So I'm conscious of the time here. I want to make sure that we have some time for interaction with the audience. So I'm not going to do a full second round of questions here, but I'd like to let any of the panelists respond to anything they heard from the other panelists. And I do want to give a special dispensation to David to say a bit about public lands, because you actually stayed to the 7 to 8 minutes that I had asked. And I appreciate that. And you traveled the farthest. But all of those were incredibly rich interventions, and I really appreciate what everyone had to say. But I do want to protect our time for Q&A, and then I'd like to get a last round of comments from all of you, but I'll come back to that. So David, if you want to say briefly a bit about your public lands point, and then if anyone else wants to comment on something they heard, and then we'll open it up.
Okay, thank you. So on the theme of the importance of California, back to the current legal skirmishes that are occurring, Javier Becerra, your Attorney General, has played a key role in terms of some hugely important public lands issues where environmental rollbacks are being attempted by the Trump administration. This is public lands are important for a couple of reasons. It's about a third of your state. It's also about a third of our country, and it's our offshore waters, and it's a place where the feds have the keys to the castle. So when they're interested in helping the fossil fuel industry, they can do it directly by making changes to the public lands, by thinking about opening up new areas for oil and gas drilling offshore, all the Pacific, Alaska, East Coast. It's not going so well because of AGs, including yours, but also in terms of the very substantial oil and gas and coal operations on public lands. I told you about the NYU Policy Integrity website. I mentioned the New York Times website. You got to look at our website too. It's if you Google NYU State Impact Center, this gives you a lineup of all of the hundreds, scores, not hundreds, scores of important pieces of litigation. By the way, you can also click in by state, and Javier Becerra is number one in the number of actions that he's brought. It's 109 as of 6 weeks ago, so by now it's probably 120. But I want to also, for all of you wonky lawyers out there who are interested in what's happening in the courts on these rollbacks, two public lands issues you should look at. One deals with the question of the Bureau of Land Management not allowing the venting of methane from oil and gas operations on public lands. Methane is a very powerful greenhouse gas. Right now, there's a huge amount of venting going on our public lands and our private lands because it's cheaper to get the oil that is there with the gas is more valuable than the gas. There are not enough pipelines in the Permian Basin and North Dakota to get the gas out. So let's vent it or combust it incompletely and have lots of methane going up. The Obama administration said on our public lands, the federal landlord is not going to let that happen, had a rule that required, that limited how much venting should occur. This was one of the number one targets for the Trump administration. They tried to delay the implementation of the rule, and General Becerra brought the lawsuit in the Northern District of California. They slapped down the delay, so then they went to a complete rollback. We're just not going to have any of these requirements. And within hours, General Becerra last fall sued on that. And tomorrow, General Becerra is filing the lawsuit, rather the pleading, to move for summary judgment to overturn that rule. So that's happening right now. And it's on the heels of a similar public lands case that involved a reform of the royalty system for coal companies and oil and gas. There was a fraud going on. In order to reduce the royalties that coal companies and oil and gas companies would pay to the federal government, they did an inside trade to set the initial price. The watchdog said this isn't right. There was a reform done by the Obama administration that essentially required there be a market transaction for that royalty. That was in the crosshairs of the Trump administration. They tried to avoid the implementation of it. Court said no. General Becerra was in the lead. Then they just repealed the damn thing again. And on March 29th, the Northern District of California issued a fabulous opinion that explained we're vacating that rule, that because you did not, Trump administration, explain why you were on the record that we had that there was a fraud, that it was okay to just go along with the fraud. That you're allowed to change the rules, but you have to have a rational basis for it. And this is these cases personify the guts of the legal arguments that we're all hoping, frankly, will be applied also to the more significant, even more significant rollbacks for the car rule, for the coal rule, for the oil and gas methane rule as well. So, end of my commercial, and State Impact Center, NYU. Yeah. So after you finish your nighttime reading on the William and Ann's book, you can move to our website.
Yeah. Any comments, Ken or Ann?
Well, just to make this the point that it's a seamless web. So the DAM satellite of this panel's title is going to be flying an instrument created by JPL that does point detection of methane emissions. And so this is yet another California worldwide effort, which means that if we can identify point sources of methane emissions, which California has actually done on an airplane on a larger instrument, if you identify the top 100 sources in every jurisdiction around the world through these satellites, then you can reduce a very significant percentage of the emissions, including some of the ones David just talked about.
Yeah, just one comment. I think a byproduct of these great relationships that have developed among the states and among subnational jurisdictions is not just that California can lead and teach the rest of the world, but that we have a lot to learn from other jurisdictions as well. And there are a lot of interesting initiatives going on in other states that California hasn't necessarily replicated. And so I just think it's important to stress that the learning goes in both directions, and we should, as great as we are, keep that in mind.
Very true.
And these coalitions and platforms are what climate governance looks like in a post-Paris world. I mean, in a bottom-up world, that this is all we've got in some ways. And California is such an important leader in so many of these, but I think it's very humble when they come to these coalitions, and certainly in the ones that I've seen, and is really inspiring to a lot of other jurisdictions. So let's open it up to other to the audience here. I see one all the way back there, and I guess I'm supposed to repeat the question for the recording. Is that right? Yeah. So we'll start all the way back there in the corner, then we'll come down here.
All of you have emphasized how important the international is. And I wasn't here for the morning session, so I don't know whether this got brought up. Today, India made the announcement that they wish by 2026 for platforms like Uber and similar to all be forced to go electric. Do any of you see any instructions to that going through, or what are your opinions? And in the interest of time, I'll say that one of you should answer so that other people get questions.
So, as I heard the question, so views on India's efforts to electrify transportation, and maybe this goes to you, Ken, in thinking about Under 2 and other platforms as delivery systems for these kinds of technologies, and lessons that have been learned in places like California.
So that's great. I'm glad to hear it. Of course, India doesn't have anything like the infrastructure to handle that. They don't have charging stations, for example. They don't have the electrical infrastructure. So the good news is that China is they have a city in China right now. This is why, they do a pilot. It's larger than the population of the U.S. They have a city now that has 16,000 electric buses. They just said, okay, let's do that. They're apparently building some cities that will be about creating electric vehicles. And so if India is going to get to where they're saying by 2026, it's inspiring, but it's probably going to be the result of the efforts of China. And so one of the first things that the California-China Policy Institute is going to focus on is an exchange between California and China around electric vehicle infrastructure. And so if that is successful, and the pilots in China and hopefully in California as well are successful, then that, I think, will spread very quickly. And I'll add one other thing, which is California's goal over the next few years is to get to 100,000 charging stations in the state. And that will dramatically change people's relationship to the vehicles.
Down here.
Maybe for David and Ann. David mentioned that 38 out of 41 cases have been lost by the government. Given that we currently have a president who told the head of the Customs and Border Patrol that if the head of the CBP ignored the law on immigrant and refugee entries to the country, he shouldn't worry about it because if he got caught, Trump would pardon him. Do we know for a fact that the Trump administration isn't ignoring the rulings that have gone against them?
So just to repeat for the recording, do we know if the Trump administration is taking seriously these 38 losses to date?
They have been taking it seriously, as far as we know. There have been a number of cases where the lawsuits have been filed and the administration has dropped its previous attempt. These tend to be very black and white, if you will, in terms of the law. The rule is, if the court says the rule is vacated, the rule is vacated. So that's not been an issue, I would say, at this point. And
But he controls these agencies that oversee these regulations.
yeah. Well, I'm a Pollyannish lawyer who still believes in the rule of law, and it may be happening right in my field of vision, but I'm hanging on to those victories, and you can be sure that if, in fact, they continue to drag their feet, and that's what they've been doing. A lot of this litigation has been holding them to the requirements of the Administrative Procedure Act, and the AGs have been after them. And the AGs have also not been shy about the potential mischief that has been occurring. For example, General Becerra has brought a lawsuit to get behind some of the documents that are flowing between the Department of Transportation and EPA on the Clean Car Rule. So again, I'm going to stick to an optimistic view that the rule of law in this area will hold.
And
Can I just add two things? One is, on some of these rules, we're talking about rules that apply to big corporate entities, which are not likely to probably to flout the rules. So the car rule would be a good example. It's not effective yet. There will be a big question if the Trump administration carries through on its threats and does in fact freeze the standards, et cetera, about what goes into effect in the interim, right? There'll be a battle over, do we keep the existing rules while we litigate, or do we put the new rules in place? But I do think when these are aimed at big corporate entities, we're likely to see compliance. At the same time, enforcement budgets have been cut. Although Congress has mostly overturned the Trump administration budget proposals, I do worry about long-term cuts in the administration, in the EPA, the sort of I can't think of the word, but the fact that very good people are leaving because it's not a pleasant place to work, and the loss of human capital over time with respect to things like implementation on the ground, enforcement on the ground, I think those are real concerns. But I think they're probably not kind of direct flouting of laws so much as entities deciding that the calculus might allow them to cheat on the edges and so forth. And I think we don't know the full effects yet of what the kind of the gutting of the administrative state that the Trump administration is at least trying to accomplish will do in the long run to environmental protection.
right here.
I'm an environmental historian, and I've learned an awful lot in the symposium so far. My question is, it's more of an observation. I guess I'd like the panelists to respond to it, if you choose to. The focus has been on the public sector to a very large extent, not the corporate sector or the civic sector. In my work on a book on the history of environmentalism in California, I've been paying a lot of attention to the role of civic sector groups. I'm thinking of the Sierra Club founded in 1890, which is now talking about international and global outreach, really powerful. I'm thinking of the Redwoods League, 1918. Their activity led to the legislation to save the redwoods. I'm thinking also of Save the Bay group that was formed by three Berkeley faculty wives back in the 1960s, and that led directly to BCDC and the first coastal regulation agency in the United States. And then Citizens Climate Lobby formed about 12 years ago, I believe it is. It's now international, and they have a piece of legislation right now before Congress. My wife and I are going to be going to Washington, D.C. in 2 days to lobby on behalf of that, the Innovation and Carbon Dividend Act. Could you just say a word or two? What are your thoughts about the role of the civic sector in California's leadership nationally and internationally, environmentally?
And just so we can get it on the recording, my apologies, the role of civil society groups or civic society groups and environmental advocacy groups, in environmental policy.
Let me just speak to the litigation piece and then ask Ann to expound on it. I mentioned earlier, but probably didn't emphasize enough, most of these pieces of litigation I'm talking about in terms of protecting these bedrock environmental values are brought not only by state attorneys general, but typically alongside major environmental groups, including grassroots groups. And there have been a number of cases where it's really been that civil society-based litigation that has had the big impact. For example, the lawsuits to stop the unraveling of national monuments like Bears Ears The AGs are amicus briefs, but the primary litigants are grassroots groups. The XL pipeline has been stopped, not by state AGs, but by environmental groups and local grassroots groups. The folks worried about the boundary waters in protection from new mining up in Minnesota, same thing. So there's a tremendous symbiotic relationship, actually, between many of these public officials in progressive states and civil society.
Yeah, let me just add a couple examples from the air pollution world. One is that the 1970 amendments to the Clean Air Act were adopted in the wake of the largest and first Earth Day, and so there was enormous public outpouring of support for cleaning up our air. Richard Nixon thought it was a political imperative and created the EPA, so that's an obvious example. The California exception that was adopted in the mid-1960s, giving California special authority to regulate mobile sources, came about in part because a local DJ got on the air and drummed up a huge postcard campaign. So if you think about, today you can just click and send something off. People had to write postcards to their members of Congress, and they did so successfully and persuaded Congress to keep the exemption. And then the third is that the California voters rejected an effort to overturn AB 32 by initiative in the middle of the recession that really, I think, was a kind of signature signal to the legislature that the voters of the state cared about environmental issues and were willing to put their money where their mouths are.
I want to
There are
add,
many more, but
I want to add one caveat, though, which is that my experience is that often NGOs, civil society, is better in opposition than they are working with allies. And I wish we could make some improvement on that. Incredibly, incredibly important right now with the Trump administration, as was just discussed, but working necessarily with allies in government is not always as good.
and the Green New Deal will be a great new test of that, I think, where you have lots and lots of civic engagement. But whether we can actually develop that into workable policy, I think, remains to be seen.
So I'm going to take one more question all the way back there, and then we'll have a final round of comments.
Well, thank you that you mentioned the Green New Deal, because it seems quite silent here, and I wanted to know, the big elephants in the room are Wall Street, oil industry, and the buildings and trades unions. And as you guys all work for Sarah, Brendan, and Brown, respectively, the Sarah was the congressman for a district that went for Bernie, but he had to vote for Hillary as a superdelegate because of that elephants in the room machine. Brown has still thousands of drilling, and the other, Brendan, who just shoved in the buildings and trade guy for the editor chair of the Democratic Party, as a recent Democratic delegate for the 9/11 vote, to realize that the real elephants in the room are certain unions and certain financial things. How, instead of being brilliant reactivists, as he asked about environmental activism, how do you see yourself in getting buildings and trades either decoupled or really truly brought to a just transition, so we can get those elephants in the room that really run our party and the way everything is?
So the question, as I hear it, is that there are at least three elephants in the room: Wall Street, big oil, and some of the unions, and that this is affecting the Democratic Party's agenda, perhaps, and that you'd like to hear more about how to deal with that in the context of proposals for a Green New Deal and just transitions and things like that. Is that a fair rendition? Yeah. Take it away.
I'll take. So I'm going to punt on the question, but shift it to a different dynamic that I think is happening right now, and that is that I think for the first time since I've worked on this issue, we are seeing genuine grassroots, deep support for climate action, and we haven't had it before. And that makes it really easy for Wall Street and the oil industry and the labor unions to defeat progressive proposals. It has to be the case that there is strong grassroots support, and I am more heartened by what people in their teens and 20s and 30s are saying and thinking about climate change than I've been in a long time. And I don't think without this generational shift we get there regardless of the elephants in the room. I think the only way, I guess, you overcome those elephants is for people to make it clear that they care about this issue. They will vote with this issue. They will continue to hold Democratic candidates feet to the fire on climate change and continue to tell pollsters that climate change is the number one issue that's going to drive their vote, not number 11, which is what it's been for the past, 15 years. It's not a perfect answer, but I don't have anything else.
My angle on this is that the clean energy economy has gotten Wall Street's attention. It's gotten the union's attention. It's got everybody's attention. And that combined with what Ann's talking about, what the people care about, is having a profoundly transformative impact right now. Just in the last 2 years, it's stunning how many states have committed to decarbonize their electricity sector in a big way, like going to 100%. You're talking about Washington State, you're talking about Oregon, you're talking about New Mexico, obviously California, you've got Illinois, you've got Michigan, you've got New York, you've got Massachusetts, Maryland. These are committing to transform their electricity sector, which we expect to get bigger if we can move the transportation sector over to electricity. So maybe I'm the Pollyanna again, but there is the opportunity to bring these economic, labor forces, et cetera, together with this agenda. And it's the most optimistic thing that we can point to today, which is in part because California has shown that there is a future for utility scale solar, for example, and has proven it, and is in the process ahead of everyone else, showing the electricity sector can move to decarbonization. That provides me with a lot of optimism on this.
So Mary said this morning that Jerry Brown said not too many enemies all at once. And if some of you may remember or have read the environmental movement in the U.S. around 1970, primarily led by students, but managed to vote out of office about 4 senators primarily on environmental issues. And the next day, 100 senators became environmentalists. So, picking up on Ann's comment, I think that people need to either win or lose an election based on this issue, and then we'll have a very significant change.
Okay, final comments very briefly. What advice would you give to the Newsom administration regarding California's leadership on climate, energy, and environmental policy? And maybe I'll start with you, Ken, and work this way.
I'm really reticent to give
Well, then talk about something else.
advice to the next governor, having having had mixed results and giving advice to the previous governor.
This is what you can do as an academic.
Yeah, right. I guess I got to get used to my new role. Look, I think taking California's, I think Ann said it well, that it's a combination of humility and leadership. People look to California around the world. Let's capitalize on that without being arrogant.
I guess my advice would be to never forget how important California's role is in the export, not just of policies, but of technological innovation and of policy implementation. I think actually I'll say this later this afternoon in our wrap up, but one of the things that was striking to me this morning from our incredible panelists was just the incredible intensity of detail in which you have to focus in order to make these policies become a reality. And California can show that to other jurisdictions, and that's extraordinarily important. And so not forgetting that our leadership role expands beyond just rhetoric and expands beyond just a bill or a piece of legislation, but also in exporting technology and exporting know-how about how to make things actually happen.
I'm going to get in the weeds just very briefly. I think that really pertinent to what both Ken and Ann said, California is in the pole position to show the rest of the country that, in fact, we can decarbonize our economy. They're doing it. But the next phase is going to be particularly difficult, I think, because we're still dealing with regulatory structures and organizational structures like utilities that aren't modeled for the type of enormously smart technology developments that can take advantage of the many changes that are occurring in terms of energy use and deployment and being much more efficient about it. So there's a governance challenge, I would say, that California is facing and is first in line among all the other states in taking on. And if Governor Newsom can look at this fresh and be prepared to potentially move in new directions, taking advantage of the incredible talents here in California and the commitment of Californians to change, that could have a dramatic impact on the rest of the country and the world.
Great. So please join me in thanking our panelists.